my submissions as to the material differences point, the section 23 point, in relation to the claimant and his preferred comparator. I hope that having looked at the regulations setting out the parental leave regime, that I have shown you the respects in which that regime provides for a compulsory 2-week period in respect of maternity leave in its true sense, and that thereafter there is a proportion of transferable leave, and that the point of that leave is for the purposes of facilitating childcare, and that it can be carried out by either parent. And my lord, my lady, if that is right, then the claimant is entitled to do as he did in the employment tribunal and adopt as a comparator a woman taking a period of leave after 2 weeks following the birth of her child, which is, in the circumstances of this case, described as maternity leave. I've also...
chooses a comparator, a woman
who is taking leave after a period of 2 weeks after the birth.
So it's weeks 3 to 14.
Weeks 3, indeed. A much more elegant way of phrasing it.
who's taking maternity.
She's taken her compulsory maternity leave, and she is now, thereafter, we say the compulsory maternity leave is really the only genuine maternity leave for these purposes.
She's taking leave.
She's taking leave thereafter, and the purpose of that leave is to facilitate the care of a child, and it is leave which either a man or a woman could take.
And it's the sole purpose of mother taking leave in weeks 3 to 14, you say, is to care for the child.
If I needed to say that, then that is what I would say. I think, in any event, I would say the predominant purpose of the leave thereafter is to facilitate the care of the child.
Well, you don't have to go that far, do you? Because it's up to the woman to decide how much time she's going to take as maternity.
Yes.
So you need only say, I think, that given that in order for this to arise, she must have decided to curtail her maternity leave. Any leave taken after that must be in relation only to the care of the child.
Indeed.
Well, I don't think you're postulating putting forward that the proposition put before. She's terminated her maternity leave. She's simply any leave that she's taking after that time is predominantly for childcare.
Oh, I see. Yes,
I think that's what.
You have to compare him with a woman who is taking maternity leave.
Well, I think yes. I think firstly, I say that although it may be described as maternity leave, if we're looking at maternity leave in terms of the strict requirements in respect of that leave, it is a requirement that it only encompasses the 2 weeks after birth.
No, I was simply clarifying the point,
I
which I slightly confused me when you were agreeing with my lady, that the assumption is that she's terminated her maternity leave after 2 weeks.
Oh, I see. She doesn't. No.
That's not part of the assumption.
It's not in
That's all I was querying to make sure I understood what the point was.
Okay, thank you. I think I've addressed you in relation to section 36B.
Can I just ask this question?
Yes.
You gave a number of reasons why section 13(6)(b) should be interpreted narrowly.
Yes.
Both in relation to pregnancy and childbirth, and in the words in connection with.
Yes.
And one of them was that this operates by way of a derogation in accordance with usual EU principles.
Yes.
And I just wanted to put to you, just to test that,
Yes.
whether, of course, when you look at it in one sense, it appears to be like that, because 13.1 sets out the general rule about discrimination, and then 6b is, in a sense, an exception from it.
Yes.
But it might be said that that particular analysis doesn't really work in the general context of EU provisions for derogation from rights, because all that is doing in 13.6b is really reflecting the PCP itself, which is maternity. Or being a woman, is it?
Well, it's reflecting the policy that in order to give women equal treatment with men, they have to have special treatment for pregnancy and childbirth, and it's not a matter of giving them an advantage over men, but a matter of attempting to bring them up to the same level as men in participation.
Yes.
So I think what we're saying is that it's not right to regard giving special treatment to women for pregnancy and childbirth as somehow derogating from the men's right to equal treatment. Or that's not how it's regarded in the directives.
I'll just take a moment to reflect on that. It may be that, well, not it may be. Strictly speaking, the provision at 13.6b is not a derogation in any formal sense. I would accept that. What I would say, however, is that any provision in domestic legislation which seeks to offset the operation of a general principle here of equal treatment has to be strictly interpreted. So I would accept that the legitimate purpose of 13.6b is to seek to level the playing field in respect of specific disadvantage that flows from the fact of pregnancy and childbirth. I would accept that, but that doesn't release us from the obligation to ensure that that provision is not given any wider scope than is necessary for that legitimate purpose.
Thank you.
And the just to finish off, looking at that provision, of course, if it doesn't apply, then the prohibition on discrimination, the general prohibition on discrimination, direct discrimination, applies with its full rigour. I, at the outset, addressed you, my lords, my lady, in relation to the regime that Parliament has put in place in terms of both maternity leave and shared parental leave. And we have considered those provisions in a little detail. I also drew your attention to the policy considerations that underlie this area, that is of more equal sharing of both parental and work responsibilities as between women and men, with a view to increasing overall substantive equality. If I can just pause to reflect on the consequences or the effect of the respondents' position in terms of failing to extend the opportunity of enhanced pay to men who take leave to care for their children. the effect of that is, in my submission, diametrically opposed to the underlying policy of the legislation, which is also, as we've seen, a significant underlying policy of the EU law in this area. So if one, so far you've been addressed from an employer's perspective, which says we want a woman to be able to stay at home and to look after her child. That approach offers a financial incentive to mothers to remain at home as primary carers, and for fathers to stay at work as primary breadwinners. I use those expressions to demonstrate that that approach reinforces rather than reduces traditional gender-based roles. And what I say is that extending enhanced pay for leave to care for children would offer genuine choice, and it would offer that choice to both fathers and to mothers and partners. It would remove the pressure on women to exercise their choice in a particular way, and it would in no sense undermine whatever choice results from that process. So a woman who wishes to see out her full 52-week entitlement to care for her child is able to do that. But equally, a father who wishes to take time out to care for his child is able to do that upon the curtailment of leave. And that care, qualitatively, in my submission for these purposes, is entirely the same.
Why should it just be a question of the rate of pay? If you're right, why shouldn't father have the right to statutory leave, whatever you call it, parental leave, from week 3 to week 52?
Perhaps I'm not ambitious enough, my lord. From a principled stance, there is no reason why. If there is a difference in the benefit, then the difference, if it is discriminatory, should be removed. I had said that I would touch briefly on some of the cases, and I think in particular it was Hoffman
Yes.
that
Yes.
required some attention. We've already looked at it behind tab 1s, and of course you will have noted the fact, so a father who took unpaid leave from employment to care for his child, where the mother had not claimed an additional maternity leave period and had returned to work. I think in my skeleton argument, I deal with the I think I mentioned that this is a case which was decided some time ago, 1982 case, decided in 1984, reported in 1985. And so, as we have said in our skeleton argument, it preceded many of the significant developments in legislation and policy that have been designed to give effect to the principle of equal treatment between men and women. And there are two matters in particular that it's perhaps instructive to consider. I think everybody has highlighted the passage from paragraph 24 of the judgment. Bear with me, I will find the
We don't have
page.
paragraph numbers.
It's at page. It's at page 764. And it's dealing with equal treatment between men and women as regards working conditions. It sets out the principle, and then it sets out a number of matters which I draw your attention with. You will have seen the references to the principle of equal treatment at paragraph 19. To make good my submission that this is a case which, if not, I don't want to use the word historic in terms of its interest or application. It certainly reflects values and approaches which would not find favour in my submission in our brave new 21st century world. And what's in my submission important to note is that at paragraph 24, when it refers to the Equal Treatment Directive, it notes that the directive is not designed to settle questions concerned with the organisation of the family or to alter the division of responsibility between the parents. So you see very clearly that it was a decision taken before the recast framework directive set out the rather more developed position, and it's before the framework directives in relation to parental leave and so on. Then if we look at paragraph 25, there are two things which it says the directive recognises the legitimacy of in terms of the principle of equal treatment. Protecting a woman's needs in two respects. And then firstly, the protection of a woman's biological condition during pregnancy and thereafter until such time as her physiological and mental functions have returned to normal after childbirth. That, we say, is the 2-week period. Secondly, it is legitimate to protect the special relationship between a woman and her child over the period which follows pregnancy and childbirth by preventing that relationship from being disturbed by the multiple burdens which would result from the simultaneous pursuit of employment. Well, first of all, I highlight the question of, I highlight the exclusion of the possibility that a special relationship might exist or require to be nurtured between an other parent, whether it is a father or a same-sex partner. The paternalistic approach, which in my submission is signalled by the language in that second limb, is in the 21st century questionable. And again, significantly, there is no recognition that the burdens that pregnancy and childbirth and participation in the labour market might impose on a woman could be relieved or mitigated by allowing a partner to take that leave and take on those particular responsibilities. Those are some illustrations of the respects in which the thinking in the Hoffman case represents, at its most generous, 20th century rather than 21st century thinking. And can I also draw your attention at paragraph 26, where what is said about the provisions of Article 2.3 and the protection that it offers is set out. One of the things that's notable in my submission is that there is a recognition that, in principle, a measure such as maternity leave, which is granted, can fall within the derogation. But there is no necessity that it does. What that, on any reading in my submission, directs us to consider is whether, in fact, the measure is targeted towards the legitimate aims in the directive in terms of protecting a woman in connection with the effects of pregnancy and childbirth. So there must be some evaluative and critical assessment of that matter before one can reach a conclusion as to whether or not, in fact, the provision or the measure in question falls within the derogation. The approach in Hoffman has been criticised more recently by...
So where did I read, I'm trying to remember, where it wasn't just the advantages of and purposes of maternity leave, they weren't just those in paragraph 25 of Hoffman, they were set about 5 of them, or 6 of them. I think that was a CJU charter. I may be wrong.
My Lord, you were addressed by my learned friend Mr. Basu on the 6 purposes of maternity leave. I'm not sure if that's what you have in mind.
Yeah, but well, maybe that's what it was. But where did we pick that up from?
My Lord, Mr. Basu told you that those were drawn from this case, the Hoffman case.
He said the first 4 were.
The first 4 were, and then he accepted that there was a 5th which related to childcare. He'll tell me if I'm wrong, but my understanding of the submission was that was a distillation from the cases that are before you. With the first 4 of those, I think, drawn from the Hoffman case.
I think the 5th was the breastfeeding purpose, which is from the Rocker-Alvarez case.
Which case?
Rocker-Alvarez.
Tab 16.
Yes. If it's before we, and I will take you to that case. I can do it now, or I'm going to do it shortly.
Do it in your own course.
Thank you. If I can take you next then to, in the authorities bundle, tab 6, which is the case of Griezmar. This is a case in relation to pay and pension credits. It was referred to, I think it was referred to earlier, in fact. It's a case where women workers were entitled to additional credits in terms of pensionable service. The reason why I would invite you to consider this case is that at paragraphs 39 through to 45, so let me just find the references for those. I think that's at page 126 through to page 127. The court considers the question of whether whether there is a comparable treatment if behaviour is focused on the role of a person as a parent rather than as a mother. In fact, we can probably, perhaps I can just leave it with the head note. I do apologise. If we go back to page 97, at the top of the page, you see the proposition set out that measures designed to protect women in their capacity as parents, which was a capacity which both male and female workers might have, could not find justification in that provision of the directive. So there was no protection under the directive for treatment that relates to the status of parent as opposed to the status of women workers as women. There were just one or two passages in the in the opinion of the Advocate General in this case, which I wanted to draw to my Lord, my Lady's attention, because they recognise in a way which perhaps Hoffman did not, that maternity and motherhood have a whole raft of meanings. And for example, at page 113, paragraph 67 of the Advocate General's opinion, we're still in tab 6, at page 113 of the report, and it's paragraph 67. Which makes the point that a distinction is made between biological motherhood and non-biological motherhood. And when one is looking at the biological mother, we can see that, for example, at paragraph 70, the biological mother enjoys a special position in terms of her employment at the time, before, during and after giving birth, and that it derives primarily from a statutory maternity protection provisions, which comprises a prohibition on employment, that's the 2-week period, the minimum period of maternity leave, and an option of extended maternity leave. Why I draw this particular Advocate General's opinion to your attention is what is said at paragraph 69, immediately above that. In order to determine whether there is unequal treatment on grounds of sex, it is necessary to establish whether motherhood within the meaning of the provision is to be understood as synonymous with parenthood, or whether there are objective grounds for treating motherhood differently from parenthood, in this case for the purposes of pension rights. In my submission, it may be helpful when one is considering the facts of this case and the leave in this case to ask whether the use of sex or motherhood or maternity is used in a context which is or could be synonymous with parenthood, or whether it is being used specifically in relation to sex. And that may shed some light on the true purpose of the leave and the nature of that leave.
Doesn't this go round in a circle? Rees-Mogg doesn't seem to me surprising. A provision which says that a mother of children any age is entitled to better terms than a father of children of any age is plainly got nothing to do with pregnancy, childbirth or maternity. It's simply simple direct sex discrimination. But that doesn't tell us, I think, whether the provisions we're looking at here fall within the classification pregnancy and childbirth or more general sex discrimination.
My Lord, I would accept that they don't tell us. What they do remind us is that there are social and cultural elements to maternity, not just biological physiological ones, if I can put it in that way. I would, if I may then, move on to look again, I hope relatively briefly. Before I do that, if I just pull together the propositions that I say can be derived from both Hoffman and Griesmer, they establish the parameters of the permissible derogation from the principle of equal treatment in broad outline. The purpose of an ostensibly discriminatory measure is obviously to be questioned and interrogated. If it relates to one of the purposes identified in Hoffman, so if it relates to biological protection, then it may be justified within the exemption. If it relates to special treatment in relation to pregnancy and childbirth, one has to give it even greater scrutiny in my submission, and one has to particularly ask the question, does it genuinely relate to pregnancy and childbirth, or does it relate to an aspect of parenthood, which could be performed equally by men or women? If it falls within the latter, then clearly it's not caught by the exemption or the derogation. The other two cases that I did want to just briefly look at are those of Alvarez and, if I deal with Alvarez first, and then if I have time, Bertieu. These cases, I say, assist because they look at whether a measure relates to pregnancy or childbirth or to an aspect of parenthood that could be performed equally by either parent, and they do that by reference to more prevailing modern standards than Hoffman did, and they have regard in particular to the policy that we've already identified in terms of the breaking down of traditional gender roles and encouraging equal participation by women and men in working life and family life. So we find Rocha behind tab 16. And it was a case which concerned a statutory right under Spanish law, which had historically been called breastfeeding leave, and it was a benefit which allowed a woman who had given birth to reduce her working hours to care for a child under the age of 9 months. It was a right that was available to fathers, provided that the mother was employed, and the claimant, a male, sought permission to take that leave in the place of his wife, and the court considered the question and decided that the leave in question had become so detached from the purpose it was originally designed for that it could be regarded as time for general feeding and care of a child, and it could be carried out just as well by the father as the mother. So it was not a measure that fell within Article 2.3. It was not, the court concluded, a measure which was designed for the protection of women in connection with pregnancy and maternity. Now, in that case, by the time the court came to consider the matter, there was no requirement that the person taking the leave was in fact breastfeeding. It was just a way of, it was just a mechanism to enable time to be taken away from the workplace without penalty to care for a child. And the judgment of the court illustrates that at page 879. It was common ground before the court that the leave had become detached from the biological fact of breastfeeding. You see that at paragraph 28. And so the court analysed it as a measure which reconciled family life and work following maternity leave. You'll see, however, that in this case, at paragraph 30, the court distinguished the Roker case from the facts in Hoffman. And you'll see in paragraph 31 the reasons why it felt able to give effect to that distinction. And essentially their view was that the leave was accorded to workers in their capacity as parents of the child. It couldn't be regarded as ensuring protection of the biological condition of the woman following pregnancy, nor the protection of the special relationship between mother and child. The court recognised over the page at paragraph 36 that if the leave were simply restricted to a mother, it would be liable to perpetuate a traditional distribution of the roles of men and women by keeping men in a role subsidiary to that of women in relation to the exercise of their parental duties. So there you see a sort of critical consideration of the actual effect of a measure on equal treatment as between men and women. And finally, over the page at paragraph 38, you will see that the conclusion they drew from those matters was that the measure could not be considered to be a measure eliminating or reducing existing inequalities in society, nor as a measure designed to achieve substantive as opposed to formal equality. And it did not prevent or compensate disadvantages in the professional careers of the relevant persons. And pausing there, if one is critically considering the measure in this case, then in my submission, some of those questions are questions which properly ought to be asked. So does the measure in fact contribute to reducing inequalities, and does it facilitate the engagement of women and men in the workplace and seek to balance work and family life? Those are relevant considerations in my submission in a case such as is before you. The final case I wanted to take you to is the case of Betriou and Montoul, which is behind tab 21. And this concerned a Spanish provision which provided for a period of 16 weeks maternity leave immediately following the birth of the child. The first 6 weeks of leave were compulsory maternity leave. Remaining 10 weeks were optional and could, at the mother's choice, be transferred to the father. But the right was only available to mothers who were employed. And so if a mother was not employed, she had no right to transfer. In this case, the court analysed the measure and...
If she wasn't employed, why did she need maternity?
Well,
is this
she was
paid from the government or from...
The mother was self-employed. So she had, she had elected not to be employed, and she'd opted into a different scheme that provided for a benefit rather than provided for a period of paid leave. And her partner wished to take leave, but he didn't have an independent right to do so because of her employment status, if that makes sense. Just looking at the way in which the court analysed the provisions that were in play, they considered the significance of the fact that there were 10 weeks of leave that could be transferred to the father, provided that both were in employment. And they considered, amongst other things, whether that fact took the measure outside the scope of of the Pregnant Workers Directive. So was the fact that there were 10 weeks that could be assigned to the father if they were employed, was that a fact which stopped it being focused on either the biological protection of the mother or the fostering of the special relationship? In this report, I think we have the judgment at page 135, and I want to pick it up at 1351. And you will see at paragraph 48 a summary of the case law of the court in terms of the right to maternity leave granted to pregnant workers, a particularly important mechanism of protection under employment law, is how it's described. And a period of 14 weeks preceding and after childbirth was a legitimate ground on which pregnant women could suspend their employment without effectively being dismissed from that employment. At paragraph 49, there's a statement about the the especially vulnerable situation of pregnant workers or workers who've recently given birth or who are breastfeeding, and that especially vulnerable situation is what makes it necessary for there to be a right to leave.
You say recently now means within the previous 2 weeks?
Yes. Cutting to the chase, this court, so in Betriu, they were satisfied that the opportunity to transfer 10 weeks of leave did not take it outside of the Pregnant Workers Directive provisions. So they accepted that that was a legitimate special measure and was an appropriate derogation from the principle of equal treatment. The distinction in my submission between the Betriu-Montour case and this case, and Rocha rather, was that there had been a detachment of the protection for the purposes of the mother's health and safety in connection with pregnancy and childbirth and the purpose of the leave. And in my submission, in this case, the effective legislative curtailment of compulsory maternity leave at 2 weeks is an equivalent detachment. So that is the point, we say, from which leave is out with the scope of pregnancy and childbirth, and becomes leave that is available to parents for the purposes of care.
Although the claimant lost in that case.
Yes. What I would say about the Betriou case is that whilst it does, there are a number of things. There's an acceptance that it's acceptable to make father's rights contingent on mother's rights, but it doesn't excuse a differential in benefits once the entitlement to the right is established. So the fact that a right or benefit may be exercised either by the father or the mother means that it's for purposes that could be carried out by either. And so when they actually take that right, or they enforce that right, there's no basis for discriminating as between them, if that makes sense.
But there's no discrimination here as between them when they're both taking shared parental leave.
At the risk of repetition, it is not the label on the leave that is determinative. It is the purpose of the leave. So whatever you call it, if it is for a purpose which could be carried out equally by male, female, other, then it is leave for care, childcare, and is outside these particular protection. So, pulling together some of those threads, if I may, just very briefly, the starting point is a prohibition on sex discrimination in employment. We see that both in terms of the Equal Treatment Directive, Article 14, and we see that derogation from that prohibition is permitted for measures that are intended to protect women in connection with pregnancy and childbirth. Whether or not a particular measure falls within the scope of that permissible derogation or exemption depends crucially on its purpose, and if that purpose is to protect the mother's health and safety during pregnancy, whilst breastfeeding, in the 2-week compulsory period, then it falls within it. If it is not for those purposes, then one must critically examine it, and the likelihood is that it falls outside it. And when one is looking at the second of the Hoffman limbs, the special relationship limb, one has to do so in the light of developing social mores, which include, for want of a better description, an acceptance that mothers, men and women, can be regarded as equally capable of providing care and nurturing and so forth of a child, and that it is important that those other than mothers have the opportunity to develop those strong relationships. If the effect of the provision is therefore to perpetuate traditional gender-based roles beyond the 2-week period in relation to childcare and so on, then it is not a measure that falls within the exception, and it cannot prevent liability for direct discrimination arising. If I can turn just very briefly then to pull together the threads of my grounds of appeal, I hope I have covered most of the ground as I have taken my lords, my lady, through the material, the first ground relates to the purpose of maternity leave, and I'm sure that you have my submission on that point. What I would say, just in addition to what I have already said, is that in terms of the decision in this case at first instance, the Employment Tribunal conducted the appropriate analysis, and it reached a conclusion that was open to it on both the law and the evidence, and there is no basis for interfering with it. As regards ground 2, which relates to the status of Hoffman, I've dealt with this in our skeleton argument at paragraphs 31 onwards. What I say about the Employment Appeal Tribunal's use of Hoffman is that it can best be characterised as an uncritical embrace of the Hoffman judgment, and the lack of inquiry caused it to fall into error in reviewing the Employment Tribunal's judgment. In particular, the developments post-Hoffman, which had a bearing on both the interpretation of the relevant statutory provisions and the matters of social policy that underpinned those provisions, appear to have, if not passed the Employment Appeal Tribunal by, certainly not been given the weight that they should have been. Grounds 3 and 4 deal, I think, with the case of de Bellin and the applicability of section 13(6)(b). Again, I've dealt with that. You have my primary submission, which is that we don't even get into 13(6)(b) territory because this is out with the scope of the exemption. In the alternative, I do adopt the position in the de Bellin judgment, which is that if one is considering 13(6)(b), one has effectively to import in a proportionality assessment and ask oneself, is the measure directed towards a legitimate aim, and is it a necessary and proportionate way of achieving that aim? And that analysis...
Sorry. Which point are you now? What is the,
this is grounds 3 and 4. So it's
yes,
the...
I know that.
Yeah.
What is the point about legitimate aim?
In terms of the proportionality assessment of the measure. So if it's the payment of more money to women who are on leave to look after their children as compared to the money that's available to men, then one has to, if we are in 13(6)(b) territory, consider the proportionality of that.
That couldn't vary from case to case, could it? Either it is or it isn't.
I suppose it depends on how one identifies the aim. It's conceivable that the more agile minds than mine at this point might be able to identify the aim in such a way that slightly different principles apply, or different weights are given to different matters. But the broad thrust of ensuring that the discriminatory means are only as discriminatory as they need to be, I think is one that is of universal application.
Right, so just remind me how proportionality gets into this issue.
Well, it gets into this issue if it is necessary to look at 13(6)(b), and if one is then asking the question, do the measures adopted, are the measures adopted in connection with pregnancy and childbirth?
Yes.
And what de Bellin says in the Employment Appeal Tribunal, albeit obiter, is that if you are in that territory, the measure has to be proportionate. You have to consider whether or not it's a proportionate way of achieving the desired aim.
Right.
So,
You know, you're accept. There's no dispute about that. That's an ethical principle.
well, it's not my primary position, but I accept that if we are in that territory, then one has to weigh in the balance the discriminatory effect and the legitimate aim in order to make a decision about 13.6b.
But how does the statutory regulation disparity that exists in the first 6 weeks of maternity pay affect that? Well, one had to be careful not to get into a situation where higher earners, who 90% of whose average weekly earnings are considerably more than the £138 a week, whatever, would have a claim, whereas less well-paid people for whom the differential was much smaller wouldn't have a claim. So I'm not quite sure whether it could ever be disproportionate to pay someone 100% rather than 90% of their weekly earnings, however that compares with the statutory rate for shared parental leave.
In Mr. Ali's case, the provisions in relation to pay were more generous than the statutory provisions in relation to maternity leave. So in his case, I'm just trying to consider that question. If it is less favourable treatment because of sex to pay a man taking leave to look after his child more than it is to pay a woman taking leave, then the consequences of that less favourable treatment are what they are, irrespective of the level of pay. So if it's discrimination, then the results that flow from that are not affected by policy considerations, if that makes sense.
I'm not sure. What's happened about? Can we get back to this question of proportionality and legitimacy?
Yes.
So presumably it's your case that if, as the EAT found, we're within
Yes.
13.6b,
Yeah.
then you have to go and consider this question of proportionality and
Yes.
legitimacy.
Yes.
Are you saying the EAT didn't do that, or that it did do that, but it didn't do that properly?
Well, the EAT didn't do that because it said it didn't have to. It said that there was no, it didn't arrive at the point where it had to consider proportionality because, well, I'm not quite sure because why, but it considered that it didn't arise. The 13.6b exemption caught this treatment.
Yes. So I'm just trying to. So was the decision in the EAT that once you're within 13.6b, you don't.
That's the
issue of legitimacy and proportionality don't
yes.
apply.
That was the end of it. Whereas in De Bellin, what was said was that in order to answer the question of whether 13.6b applies or not, you have to consider proportionality.
So there's a conflict at the level of the
Yes,
EAT.
there is.
Oh, right. Okay.
Yes.
And right. Is there anything you rely upon in relation to that issue other than the onus statement in De Bellin?
No.
All right, so it's just De Bellin. And where do you? My lord asked the question. Well, does that vary from case to case, or is it a generalised issue? and I'm afraid I didn't quite pick up your answer.
So the considerations of proportionality will vary from case to case because the circumstances of the...
So it's fact specific.
It's very fact specific.
It's fact specific. And where do you deal with this? Is this in your skeleton where you deal with the factors?
It is, I think we deal with it at paragraph 45, but let me just...
When you say it's fact specific, is that from employer's regime to employer's regime, or from individual person to individual person?
Well, it's both. There may be considerations in an individual case which tip the balance one way or the other. So when I say that it is fact specific, I mean that it depends upon the circumstances of the individual case.
How can it? I don't understand that. As my lady pointed out a moment ago, the effect in an individual case of somebody being restricted to the parental leave rate of pay rather than the maternity leave rate of pay is greatest on the highest earners.
I accept that. I think what I would say is that there is a core, in terms of the proportionality arguments, there are core considerations, but how those might play out in a particular case is not certain. So I'm sorry, I'm not expressing myself very well, but when I say it depends on the individual case, the considerations that are in play are broadly the same, but the outcome of those considerations in an individual case may vary.
Well, certainly, normally one thinks of proportionality, I would agree with you, as a fact specific. On legitimacy, I'm not quite sure what that adds to it all personally, but anyway. And I suppose, I mean, you'd have to look at so the answer is you would say, well, you have to look at the case of each particular applicant, is that right? But we're talking about schemes, not discretion. Typically, we're talking about schemes which have fixed provisions in them. We're not talking about the exercise of a discretion here. So it is slightly odd. I mean, you'd have to say this. You'd have to say that particular employer's scheme is disproportionate.
Yes.
You wouldn't be saying in the case of this particular claimant, it's disproportionate. That can't be right.
No. I accept that.
So when you're talking, I'm just trying to sort of test that whole
Yes,
thing
no,
really. So I think what we're at to is you look at the term. If this applies,
yes.
you look at the scheme itself, and you say, well, is this proportional? But I question that. I mean, I haven't sort of gone into debate because your interpretation of 13.6b, which is attractive, is, well, it's got to be in connection with childbirth or pregnancy. And once you've established it's in connection with childbirth or pregnancy, using those in the narrow sense, I don't see what scope there is left for, as it were, a further narrowing, as it were, of this exemption by reference to issues of proportionality.
No, I would accept that. I would accept that.
That tends to suggest that proportionality isn't
yes,
irrelevant.
it probably does.
Well, perhaps we could say Debellin was a very particular case on its own facts.
It was, and it certainly didn't concern parental leave in any respect. And as I think has already been observed, the comments that we've drawn out were over-to comments. If I may just. That again, my tidying up is simply to again state that the Employment Tribunal did in fact consider these issues. It had the evidence, and its conclusion was that in this case the employer had not acted proportionately. If it was required to consider it, it did. But its primary conclusion was that Section 13(6)b did not apply. And then the final point I think that I had made was in relation to the comparators and how one identifies those. And again, I think I've probably rather exhausted that particular furrow. But if I can just remind you that we say you strip out the sex-related elements for the purposes of the comparison, a la Lockwood and Cole. We say maternity is necessarily gendered, and so for our Section 23 comparison, one must remove it and look at leave without any description of that leave, where the leave is for the care of a child. Because otherwise, the label of maternity becomes a trump card. And that goes far beyond the protection that was envisaged by the directive, or indeed enacted by domestic legislation. And I venture, and it may not be necessary, but it may be that the reason that the Employment Appeal Tribunal got this wrong, as we say they did, is because it was confused as between pregnancy and maternity as a protected characteristic within Section 4 and the scope of protection provided in relation to that protected characteristic, which is set out in Section 18.
Right, again, what I need to understand when
Oh, sorry.
the
Okay.
analysis, sorry, I'm just, as we're making these steps, I'm just trying to work out
Yes.
how they fit into the analysis.
Yes.
So we're now in a situation where, are we assuming you have succeeded or failed in your point that after looking at the nature of the statutory framework
Yes.
and the background,
Yes.
that after week 2
Yes.
of compulsory maternity leave, what we're talking about is essentially childcare, not pregnancy or
Yes.
childbirth. So are we assuming, when you're going on to this other point you're making now about
Yes.
stripping out maternity because it's gendered,
Yes.
which is a
Sorry. Yes, I know.
slightly
Sorry.
complex concept, which I need to understand, but are we saying you failed or succeeded on your earlier point? Because if you're right on your earlier point, you succeed, is that right?
Yes, that's right.
Right.
It goes back to a point which was made, which was that essentially said against me is you cannot establish less favourable treatment because you can't point to an appropriate comparator, because your comparator has to be a woman who's given birth and is on maternity leave. That's the point that's made against me. So if what I suppose I'm saying is referring back to that. It's referring back to the less favourable treatment question, and I'm saying it is less.
So that's a prior.
It's
so,
a prior.
So you've dealt with
yes.
it second.
Yes.
It's actually
Yes.
right. So it's a prior question,
Yes.
which is 13.1.
Yes, indeed.
All right, that's right.
Yes.
So let me just make sure I understand that. So the section 13.1 question is:
Yes.
have you got an appropriate comparator?
Yes.
Because if you haven't got an appropriate comparator to show less favourable treatment, you don't even need
Yes, exactly.
13.6.
You don't even get to 13.6.
Right, and so it said, well, you haven't got an appropriate comparator because the man hasn't given that. A man who has not given birth and
Yeah.
isn't concerned with
Yeah.
the consequences before and after that is not in the same position as a woman.
Yeah.
So, and you say you have to. That's not correct because. What you're, I put it in my own words,
Yes.
which is about my own sort of cold words,
Yes.
I put it like that, which is, well, but you're looking for unifying facts which are relevant. That's what you're looking for, and the mere fact it's a man and a woman isn't the unifying fact that you're looking for.
Yes,
Is
and
that-
yes, that's right. And
But what
fact,
you're looking for, because because I think it does relate back. Actually, I think it may be part of the same point actually on analysis. What you're looking at, the unifying factor you're looking for is taking time off to look after the child.
Yes.
That's the unifying
Yes.
factor. On that basis, you can make that comparison. But what I would put to you is, now I've got to this stage, but what I would put to you is, but that actually is exactly the same point, which is that after week 2,
Yes.
that's what you're looking at.
Yes.
It's actually the same point.
Yes. Yes.
But it comes into the analysis, I suppose, at 2 stages.
Yes. And
from your perspective.
yes, and I'm sorry, I took it. I perhaps took them in a
I'm just trying to understand.
logical. But the comparison is relevant and valid, and we say essential in this case.
And in both cases, it all turns on the fact
Yes.
it's all relevant because, and you can't succeed without this point. After week 2, there's a single unifying issue.
Yes.
Right. Thank you. The final submission I did want to make, and it draws on, or it touches on the submissions that you've had from the intervener, the working families, is about the effect of this case and the dangers that may lie ahead if this appellant succeeds. I started by saying this is not a case that takes rights away from women who work. It does not affect their entitlement to maternity leave. It does not affect their right to maternity pay. It is about equal treatment in appropriately comparable circumstances. And if there are employers who wish to... Can I just test you on one point?
Yes.
Just to clarify one thing. I suppose that what could happen, is this right, is that, yes, you're right that it would result in an increase in the men's pay on leave. That must follow. But I'm just questioning for the moment whether you're right in saying it doesn't affect women's paternity pay for this reason. If employers are paying more than the statutory minimum, one thing that they could do, if we were with you and allowed the appeal, would be, yes, the men would get an increase if the women were then brought down to the statutory minimum that the employer has to pay. So it could affect them, because overall the employer would try to cut their losses, as it were, and so they would try to equalise as much as possible. The lowest they'd have to pay the mother.
That is right. That is potentially a consequence, but it is a consequence that flows from decisions and actions taken by employers,
Yes.
not from a decision of this court.
If your client wins, there is then a disincentive for granting more advantageous pay for maternity pay, certainly more advantageous than the statutory amount.
I'm not sure that I would accept that, my lady, and can I explain why? Because the sort of cataclysmic argument that comes from the respondent's side assumes a level of take-up of leave for fathers and partners which is far greater than anything that we have seen or contemplated to date. At the moment, the take-up of shared parental leave is 2%. The best figures put it at between 2 and 8%. If what the opportunity to make a choice provides is an opportunity for those who wish to take leave at an appropriate time and receive even enhanced payment in relation to it, there is no evidence that suggests that there will suddenly be more people overall taking leave than currently take leave. It may be there may be more men who decide to take up caring roles, but if they take up caring roles, it's in order for women to return to the workplace. So there is no necessary disadvantage. I think I would put it in that way.
Okay, you can put it. I think that's better.
Yes.
It doesn't necessarily.
It doesn't necessarily disadvantage.
You just don't know.
No, we don't know. And if we are to give effect to actually achieving substantive change and improving the balance in terms of those engaged in the care of their children, then it's, in my submission, a necessary step. Unless there are any matters, my lords, my lady, that I can assist you with.
There's just one.
Yes.
As I understand it, in the Hextall case, the direct discrimination claim was knocked out at the ET stage
Yes.
and was not appealed.
Yes.
And that was on the basis that there were some women in the police force, that is the female partners of birth mothers,
Yes,
who also benefited
yes,
from shared parental leave.
yes.
What's not clear to me is why that why that didn't knock out the direct discrimination claim in your case. Was it just that the point wasn't argued, or is there something in the Capita scheme that means that it really is only men who can take the shared parental leave and not the female partners of birth mothers?
No, certainly in relation to that last question, there is nothing in the Capita scheme that restricts it to men. I don't, in all honesty, know how the direct discrimination case in Hextall was run below. What I would say is that if we are talking about access to a benefit, then the mere fact that some women may have access to a benefit doesn't negate the possibility of sex discrimination. I don't know whether that was...
It doesn't negate it, but the question is whether it turns it from a direct to an indirect discrimination. Well, that seemed to be what was decided in the Hextall case.
I think I'm going to show rather more deference both to my instructions and to the scope of my knowledge by saying that I don't think, my lady, I can assist you on that. This case was run as a direct and indirect discrimination case below initially. The focus at hearing was on the direct discrimination claim. Generally, if this assists, cases of this sort are run as both direct and indirect, and one waits to see what comes out of the wash. Thank you.
Very much indeed. No, thank you. Right, I'm sorry we haven't given you as much time left as Mr. Menzies perhaps
Well,
might have wanted.
But there's good news and bad news, isn't there? The good news is that I only have about half an hour if I'm to allow my friends to the bad news is my notes go to about at least 2 hours, so I'm going to have to be nimble on my feet. But I say that the answer to the direct discrimination case is pretty simple, and it's the matter that my lady mentioned a moment ago, for the same reason that the direct claim in Hextall was knocked out on a very basic level. The direct claim in Ali is knocked out on a very basic level. My submissions, I will go through them more quickly than I had planned, but some words of introduction on how it all fits together. A quick summary of key reasons why the direct discrimination case fails, and then broadly in the order that it's taken in our skeleton. It may be that I just leave you with paragraphs from our skeleton rather than going through them.
Well, I mean, I think what would be most helpful, and I'm sure I'll pick it up, is to answer the oral submissions that have been made. Yes.
And then I'll be looking at it, a quick look at the ET judgment and the EAT judgment in Ali. The fundamental point, which I think arises in all across this, which is shared parental leave essentially the same as maternity leave? Is a man taking shared parental leave in the same material circumstances as a woman taking maternity leave? And that is the answer to the direct discrimination question. it's the answer to the indirect discrimination question, and it's the answer to the equal pay question. And that's unsurprising because, as I will show you, I'll take you to my skeleton, the European Court of Justice have said that equal pay or equality of terms is just a subset of equal treatment, and it would be surprising if you reached a different result depending on whether you came to a inequality by looking at it as equal treatment or as inequality of terms. But the answer to all of the ways you put it is Miss Omambala's point that after 2 weeks, shared parental leave and maternity leave are the same thing, just childcare. And as I'll show you, that's been argued recently in the European Court of Justice and has failed. And that's the answer to the case, however one labels it. So, quick introduction. You're there now. Direct discrimination is the man in the same material circumstances as the woman, is a claimant, male claimant on shared parental leave, in the same material circumstances as a woman on maternity leave. That must turn on is shared parental leave essentially the same thing as maternity leave? Is it just childcare after 2 weeks?
Break that down a bit, going from section to section in the legislation.
I will.
Yeah.
If I can do this
Yes. Okay.
introduction first. Second way of looking at it, indirect. You apply a policy, a criterion or practice, a PCP, to men and women equally. There's something in that PCP which has a disparate impact. There's something inherent in the PCP which men or women have an inherent ability to comply with more than the other. So there's a particular disadvantage within the PCP. And so it superficially applies to everyone in the same way, but actually in the way that it affects people, there's an inherent disadvantage to one sex or the other. And so in this case, it must be said that men are inherently disadvantaged by the policy of paying statutory pay for shared parental leave, because something about that PCP favours women. And that's where the indirect discrimination claim fails, because there's nothing about the PCP which inherently picks and chooses between men and women. And then, of course, in indirect discrimination, if there is something inherently disadvantageous about the PCP, the employer has the burden of justifying that disparity by showing that there's a legitimate reason for it and that the employer has used proportionate means to achieve that legitimate objective. The third way of putting a discrimination case is equality of terms, old language equal pay, where there is like work between the man and the woman, or work that's been rated equivalent, or work that's of equal value. In this case, like work. Is the term in, or is a term, or is a part of the man's contract less favourable than a term in the woman's contract? So, accepting that there's like work in these cases, is the man's rate of pay for childcare leave less than the woman's rate of pay for childcare leave? Because what's said is that they've both got contracts, or in police case terms, both have childcare leave, both get paid for it, but the term about in the man's contract is less advantageous than the term in the woman's contract or personal terms of employment. And therefore the sex equality clause kicks into action and it changes the man's rate of pay for childcare leave to the same as the woman's rate of pay for childcare leave. The sex equality clause equalises the rates of pay. And the only question in the equality of terms case then is shared parental leave the same, essentially, as maternity leave? are they both actually childcare leave or are they something different? And lastly, on my quick run through the whole of discrimination, in domestic law, but not in European law, we have exclusivity of jurisdiction. So if you, as was gone through in some detail, if it actually is an equal pay, an equality of terms case, it can only be brought as an equality of terms case. My Lord the Master of Rolls asked why that should be. It's not clear why it should be, it just is and has been for a long time. Possibly for tidiness, possibly to try and avoid multiplicity of claims. You try it as equal pay once, then you try again as equal treatment or sex discrimination, but it doesn't derive from EU law. There's no EU principle saying you can only bring it as one or the other. In EU law, it's said that equal pay, or equality of terms, is just a part of equal treatment. There's a historical reason, which is that the European coal and steel community came up with equal pay first, and it wasn't until the mid-1970s that they came up with equal treatment. So there is a historical reason for why equal pay was the predecessor of equal treatment. So that's my introduction. The key point is in direct discrimination, men and women are treated identically. As the EAT said, paragraph 6, and for your notes, paragraphs 49 and 57, the rates of shared parental leave pay are the same for a man and a woman. The direct claim is straightforward. It fails for 3 reasons. Number 1, the comparator point. The proper comparator for Mr. Ali is a female worker on the same sort of leave as him. Shared parental leave, as the claimant in Hextall agrees. Second, B, the reason why point. It fails because the reason for the difference in treatment between Mr. Ali and a female worker is not his sex, but because the woman is on maternity leave and is recovering from pregnancy and childbirth. That's the reason for the difference in treatment. And so that's the second reason why the direct claim fails. And the third reason why the direct claim fails is because section 13.6 recognises that preferential treatment for women in connection with pregnancy and childbirth is to be disregarded. It's lawful.
So your second one is not that one then? Your second, the reason for the difference in treatment between her and a woman on maternity leave is that she's...
Yes, my lady, I have broken this down into 3 reasons.
Yes.
The use of comparators is a tool which enables a court to reach the reason why. And so actually, these are 3 ways of saying the same thing. A court has to decide, tribunal, what is the reason for the difference in treatment? Is it because of sex, or another particular characteristic, or something else? And the comparator in section 23 is the tool to help the court or tribunal find out the reason why. And section 13.6 actually also feeds in to the reason why, because it just says when you're doing the comparison, you must allow an employer to treat women in connection with pregnancy and childbirth more favourably. So, very briefly on the Employment Tribunal judgment and the Employment Appeal Tribunal judgment. On the Employment Tribunal judgment, I won't go to it. You know where it is in the bundle. Effectively, my submission is that the Employment Tribunal judgment is based entirely on the curious and troubling distinction that Ms. Omambala has to boldly put forward as correct to you today, that there's a distinction between the first 2 weeks of a statutory maternity leave and the remainder. That a woman only needs 2 weeks leave to recover from childbirth. Only even articulating it in that way reveals how ridiculous it is.
But just pausing there, is that a matter of expert evidence? What is it?
No, it's a matter of EU law, because the EU law requires 14 weeks minimum to recover pregnancy and childbirth, the Pregnant Workers Directive. 14 weeks is the minimum you can give. And it allows, permits...
No, I think I'll try to put the other way around. If you're going to say after 2 weeks, if somebody's going to assert,
Yes.
a claimant is going to assert that after 2 weeks, all that one's concerned with is child care as opposed to the consequences of pregnancy and childbirth. I mean, the court has to act on something.
Yeah.
Is the obligation on them to bring forward cogent evidence to that effect? Otherwise, it's just something that's being said as a word from the bench, from the bar.
Well, that's true, but it must be the purpose for which the leave is given that's being attacked. The purpose for which the leave is afforded nationally is revealed, the purpose for maternity leave nationally is revealed by the European obligation. The European obligation...
Yes. Now, I understand your response.
but
I'm really just saying it's an odd process, to my mind, for somebody to stand up and say, well, after 2 weeks, the mother has physiologically and physically recovered, so far as is required, from childbirth.
well, that's not what...
No, I think
That's not what's said. What's said is that the shared parental leave, domestic shared parental leave regulations changed somehow the nature of the European purpose for maternity leave.
because they allow a woman to curtail her maternity leave after the 2 weeks and go back to work and allow the man to do the rest of the...
But a woman could curtail her maternity leave after 2 weeks before. The shared parental leave regulations have nothing to do with it. A woman could curtail her maternity leave and go back to work after 2 weeks, except in a factory where it's 4 weeks. 2 weeks.
But there's also the oddity that the 2 weeks, according to the directive, she could take before the birth even.
No,
Not in the domestic
No,
regime, but
no, compulsory is 2 weeks after the confinement, as was called in the originally in the Euro, and that's been transposed to the domestic.
I see. So the way, and I don't want this an injustice here, or something like that. But the way it's put in, don't get any evidence on this. It's the effect of the statutory provisions as they've rolled out.
Parliament has effectively, by putting together shared parental leave,
Yes.
fundamentally changed what maternity leave is for.
Yes, I see.
That's what's said. The Employment Appeal Tribunal, I say Mrs. Justice Slade gets it exactly right. Paragraph, and we summarise this in our skeleton argument. Paragraph 7, page 38 of the Ali core bundle. And I'll perhaps just leave you with those. You've got the references, paragraph 69, the 80, 70, 72, 77. Mrs. Justice Slade is very thorough. She goes through it once, she goes through it again, and she goes through it a third time. Effectively dealing with the same reasons as we went through the submissions, but it's the same point that she deals with in a number of places in her judgment. It appears, and I'm grateful to Ms. Omabara for this, that our summary of the provisions of maternity leave, shared parental leave, and other forms of parental leave, at pages 39, 40, 41, 42 of our skeleton argument, I should say Ms. Harris's thorough expertise in researching all these types. In fact, it was Ms. Harris who immediately spotted that the 2 weeks had to be taken as compulsory maternity leave and couldn't be taken as shared parental leave, and it was only via me that Mr. Leach was shown the error. It wasn't really down to me at all. I should give all the credit where credit is due. I'm pleased to say that that's effectively that summary of where we are with maternity leave and how it works, shared parental leave and how it works, and the other forms of parental leave, which are there to make sure that you're not confused by them. Parental leave, completely different from shared parental leave, despite how close they are in language.
So you're saying it's all accepted. So
That's all.
39 to 44, down to 42, in your skeleton are accepted.
And so we don't need to. The one thing I want to just add to emphasise is that it is a curiosity of shared parental leave, and my lady may have not picked this up, that I can be working for Capita. My wife could be could be employed by Capita's direct rival company, bitter rival. If she curtails her maternity leave, I get the benefit of that, even though I'm in completely different employment. It's plainly, you can see that the scheme is so that the government either pays statutory maternity leave or pays statutory shared parental leave. So the government is equal when you're paying the statutory rate only, or somebody's getting it. But it's slightly bizarre in that it acts not within the same employer, but at different employers. It doesn't make much difference to this case, but at one stage I could see it was troubling you, that it's not a comparison with somebody in the same workplace. Sorry, it is a comparison with somebody in the workplace, but it's not the woman, the mother is not necessarily in the same workplace. So Mr. Ali's wife didn't work for Capita. Going on in our skeleton to page 42, equality principles. I think we are more or less there on that. I don't need to do anything in particular apart from to say this. I quote in paragraph 22 of our skeleton, page 43, section 13.6. It was pointed out by Miss Amambala that the words are pregnancy or childbirth. We quote in paragraph 23 the recast Equal Treatment Directive, from whence 13.6 is derived. That uses the words, as you'll see quoted on page 43, the Court of Justice has consistently recognised the legitimacy as regards the principle of equal treatment of protecting a woman's biological condition during pregnancy and maternity. The short point is that the European directive uses the expression pregnancy and maternity. The domestic legislation has implemented that by using the words pregnancy or childbirth. But maternity does not mean, for the purposes of this case, motherhood of a child through to adulthood. Maternity just means the period when childbirth is recent. You're the first year after childbirth, for instance, because you're in domestic law granted 52 weeks of maternity leave. It's the time when you've recently had a baby, when your baby is under a year.
I know we have to interpret the domestic legislation for leasing purposes or otherwise in its, as far as it's giving effect to some piece of EU law consistently so far as possible. But the problem normally arises where the English legislation, as it were, is perhaps too extensive, may have to be brought back into line. But we're only concerned, aren't we, with interpreting the words in the English statute here. And the EU law is not going to help on this point.
I say there's no difference between pregnancy or childbirth and pregnancy or maternity.
In the EU sense.
In the EU sense. Well, in the English language.
It's a matter of English language. I don't think as ordinary English language, I think maternity would not be so restricted.
The dictionary gives motherhood as definition number 1, and then the period after childbirth is definition number 2, and it's definition number 2.
I don't need to worry about it, because pregnancy, or indeed, one may compliment the Parliamentary Council on choosing something which is less open to and misinterpretation. They're using the word child, and maybe that's exactly why they did it.
I would agree with that. Whilst we're on 13.6, I also agree with the position that was reached between my lord and Ms Umbala that the vital words are in connection with. It's either in connection with pregnancy or childbirth, or it's not. The
That's
EAT
why
in
proportionality doesn't really come into it.
the EAT was trying to define in connection with and the parameters of that by using, is it a legitimate, proportionate matter, by saying if it's disproportionate, if we're going to give £1 million to a mother, then, but I would say that's just to overcomplicate things. The bill in overcomplicates what we is actually, all we need to do is say the words are in connection with. It's either in connection with maternity or a pregnancy and childbirth, or it's not. And if you give £1 million to a mother, that's not really in connection with, properly in connection with pregnancy or childbirth. There's a disconnect there. But the way in which Mr. Justice Underhill dealt with that was by importing the EU concept of legitimate, aim, proportionate means to try and get there.
Then we're going to get a whole exposition of what proportionality means.
Yes. Better, in my submission, and I think Ms. Umbala's in that position as well, just to stick with the words in connection with. We all know what that means. And it does give they're flexible words, which a industrial jury in the employment tribunal can grapple with. Next is the fundamental point, effectively, that after compulsory 2 weeks, when we're in the optional, additional maternity leave period, the purpose of the leave changes from Mr. Basu's combined 6 reasons, the last of which is childcare, which I agree with and I accept it's taken from Hoffman and cases afterwards, to Ms. Umbala's point, which is that that's no longer a good law, that Hoffman is a 1985 case which should be consigned to history books and should be no longer followed. Let's just go to one case.
It's an earlier case. In 1985 when it was published.
Yes.
The judge was published, but it was actually
1982.
1982
So
case.
the reason why that is plainly not correct, and it's if we turn up tab 21 in the authorities bundle, the argument that at the moment the leave stops being compulsory, it's essentially for childcare only, and therefore the special treatment
Which tab
falls away. Tab 21
20.
was lost in Hoffman and also was lost in Montaul. If we go to tab 21, it probably is useful if you read, and fastest if you read the head note to yourselves. Now, as my lady, Lady Justice Rose spotted when my Miss Onbala was on feet, the claimant who tried to say that things had changed after the compulsory period lost in this case. Why? If one turns on to 1351, one sees that Hoffman is still absolutely the law in 2013, because although Miss Onbala took you to and read to you paragraph 48 and 49, she then skipped over paragraph 50, which says this, bottom of page 1351, that maternity leave from which the female worker benefits is intended, first, to protect a woman's biological condition during and after pregnancy, and second, to protect the special relationship between a woman and her child over the period which follows pregnancy and childbirth by preventing that relationship from being disturbed by the multiple burdens which would result from the simultaneous pursuit of employment. See, inter alia, Hoffman, Obama, and Kiski. So Hoffman is the rationale for why the employee lost in Montal. And the 6 reasons that Mr. Basu brought out of Hoffman and Alvarez are still absolutely the reasons behind maternity leave following the compulsory period today in EU law. So after 2 weeks, paragraph 50 of Montal shows us what the reasons for providing a woman with maternity leave are today. Hoffman is not in any way undermined. It is cited, and the full rationale of Hoffman is cited. And that's not just a one-off in the European Court of Justice, because one can see, if you skip on to tab 23, you'll see the cases on a surrogacy arrangement in which the commissioning mother, who wasn't herself biologically pregnant and undergoing childbirth, and therefore maternity herself, was not entitled to the same health and safety leave. Why is that? Go to page 561 of the IRLR reports. This is CD and ST, starts 2014 551 at 561 at paragraph 34. At start of paragraph 33.
You want us to read 33 and 34?
33 and 34, please.
Yes, I see.
And Z and A on the next tab, I won't take you to that, but that's the same point as, and CD is cited there. So after the recast directive, which Miss Onbala...
It's the same point in 24.
Yes. So after the non-binding EU Council resolution of 2000, the one where they failed to agree on a paternity leave directive, but agreed that they would all encourage each other to explore paternity. And after the recast directive of 2006, which Ms. Onbala took you to, several years after that, Hoffman is still absolutely the rationale for why a woman taking maternity leave is in a different position from a person who is not a birth mother, even if they're a commissioning mother of a surrogate baby. And the other cases that you were taken to by Ms. Onbala are where men and women in the same situation are treated differently. Roca Alvarez. I'm going very quickly now, I apologise.
Just go back. start that last bit again.
The other cases that Miss Onvala took you to are where men and women are treated differently in the same circumstances. And I'll just, in a nutshell, explain why that is. Roca Alvarez is behind your tab 16. As she rightly conceded, although it was called breastfeeding leave, it was just actually parental leave. It had become disconnected from breastfeeding because fathers could bottle feed. It was just a parental leave. And yet women got it in different conditions to which men got it. So that's men and women in the same situation with the same type of leave getting it under different conditions. Plainly, directly discriminatory. And Griesmer, again, authority for the uncontroversial proposition that where there's unequal access to parental leave, which relates solely to the provision of childcare, it's unlawful discrimination. And I may be banging a drum which is already echoing around the room, but just to finally deal with that point of the Griesmer case. It's behind tab 6. Miss Onvala took you to some sections of it, but can I just add the section at page 127? This is Griesmer and Minister of the Economy, 2003, 3 CMLR, starting at 5, and at 127 we have paragraphs 43 and 44 in the middle of the page on the right hand side. Page 127, paragraphs 43 and 44. And there we have, in Griesmer, exactly the same point as is made in Hoffman. According to the case law, Article 2.3 of Directive 76/2007 is intended to protect a woman's biological condition and the special relationship between a woman and her child over the period which follows pregnancy and childbirth, by preventing the relationship from being disturbed by multiple burdens which would result from the simultaneous pursuit of employment. Footnote 97, at the bottom you'll see, unsurprisingly, Hoffman and the cases that follow it. Paragraph 44, while the court has ruled that maternity leave granted to a woman on expiry of the statutory protective period, compulsory period, falls within the scope of Article 2.3 of the Directive, it has also held that measures designed to protect women in their capacity as parents, which is a capacity which both male and female workers may have, cannot find justification in that provision of Directive 76/2007. So totally uncontroversial. Where it's about pregnancy and childbirth, special treatment. Where it's just about women in their capacity as parents, which men and women can equally do, it falls outside 76/2007.
Which is the number of statutory protected periods? Which is the relevant one for this?
Well, the compulsory period in domestic law is 2 weeks for most female workers and 4 weeks for female workers in a factory.
I'm looking at 44. While the court has ruled that maternity leave granted to a woman on expiry of the statutory protective period falls within the scope of 2.3.
Yes, in Hoffman, that was there was a period of 8 weeks compulsory leave, and then there was a period of additional leave, and the father's argument that was rejected by the European Court of Justice was that the period after the 8 weeks compulsory leave was not to protect the health and safety of women who had given birth, but was just to provide care and attention to the child. That's summarised in our skeleton at page 44 of the Ali bundle. paragraph 28 of our skeleton, which sets out the Hoffman analysis, which Ms. Umbala
So
rightly.
Hoffman decided that if an employer offers more generous maternity leave than is either required by EU law or required by domestic legislation, that still benefits from the directive. It's still regarded as protecting the woman following childbirth. Is that right?
Almost. In Hoffman, the compulsory leave period was 8 weeks, which was more beneficial than the minimum required by the directive, which was 2 weeks. There was then an additional period of maternity leave after that. So, yes, what Hoffman finds is that the minimum period. Having said that, the minimum period that's set for maternity leave at all that the woman must be entitled to is 14 weeks. So the 8 weeks fell within the 14 weeks of the minimum that must be offered to a woman. It means that, so in the UK terms, we've decided that what a woman needs to ensure that she is fully recovered from pregnancy, childbirth and maternity is up to 52 weeks. That's the domestic implementation. That's what we've decided a woman needs, a birth mother needs to recover fully, psychologically and physically. And as my Lord the Last of Wales said, plainly experts would tell us that some women will recover very quickly and some women will take a lot longer. In the UK, we have said 52 weeks is the period that the woman's entitled to take, because it could take up to 52. The rationale must be.
The assumption is, of course, if she goes back to work within the 52 weeks, then you assume she doesn't need that long. But the assumption is, and she's not questioned about this, that if she takes the whole 52 weeks, it's for reasons that she's recovering from childbirth,
Yes.
even if she might have been super fit and got better very quickly and is now just.
Yes. Domestically, we
Enjoying
have.
herself.
I'm just trying to understand. I'm sorry, I'm having difficulty with paragraph 44 here. I understand 43. I'm having a little bit difficulty with 44. I'm trying to be a bit slow here.
So,
It says, while the court has ruled, this is Hoffman,
Yes.
notice to Hoffman, that maternity leave granted on expiry of what they call the statutory protective period.
yes, which in Hoffman was 8 weeks.
That's the not what the employer, that's the statutory protective period.
In Hoffman, the compulsory leave period set by the law was 8 weeks.
No, but here they're saying that even leave after that.
That's on the scope.
Yes,
Yeah, I
leave
understand.
after
That's
the
what I'm saying.
exactly.
Still within the scope of
Still within the
Article
scope of
3.
So,
76.
but it goes on to say, so on expiry of that, maternity leave still falls within the scope of Article 3. But I understand maternity there
Yes.
to be what you have said it really means, which is limited to pregnancy and childbirth. So, but it's also so I suppose it's on expiry. It falls within the scope of Article 2.3, presumably, so long as it is in connection with child. You have to read a lot into this, into
Yes.
childbirth and pregnancy.
That it is maternity leave.
Right.
And
So
then
you mean to
paragraph
sort of insert all that in the first
Well,
bit,
that's what's laden with the word maternity leave.
right?
And
It's-
then the second half of 44, a different measure, a non-maternity, but a measure that's designed to protect women in their capacity as parents, so for instance, parental leave, or childcare leave, or shared parental leave, in this case, doesn't fall within 76. Because that's for men and women, and that's about childcare, that's not about maternity. And so that's why I say this case, whether you look at it as equal pay, or indirect discrimination, or direct discrimination, comes down to the fundamental question: are the claimants right that after 2 weeks, maternity leave is just about childcare? And the EU law tells us that's just wrong. And that's...
What happens when the intervener in this case appears to be putting forward the evidence after 26 weeks, the intervener would accept that probably the in connection with pregnancy or childbirth has probably gone, and that the balance after 26 weeks is probably to do, in virtually all cases, with child care. So where would that, I mean, that must be of some materiality.
No, because we in the UK have chosen 52 weeks to allow a birth mother to recover, that is the period. And 26 weeks, with all respect to the intervener, it's a bit of a pragmatic finger in the air. There's no, one looks at the evidence and the intervention, it's about putting a finger, and it may be that the intervener is broadly right, that a lot of women, the majority of women, recover fully, psychologically and physically, from childbirth within 6 months.
I think I am sort of slightly challenging you. It's not this case, okay? So I'm trying to see the implications of this. So what I'm putting to you is that once you've left the 2-week period,
Yes.
between that and the 52nd period, right, between that and the end of the 52-week period which we've allowed, there comes a point of time when it can be said that the leave is no longer, although that's the amount of time that is allowed by statute for maternity leave, but there may come a point of time when it can be shown that the leave is no longer in connection with child care or with birth or pregnancy. That's what I'm putting to you.
I think the difficulty with the intervener's position is that the way that the EU, as I don't need to tell you this, the way that EU law works is it gives the member states a measure of appreciation in how it implements, and we've chosen to be cautious in the UK and give a whole year, 52 weeks.
Of course, you might have taken quite a chunk of that before the birth.
Indeed, that's true, because 11 weeks before.
Yes. So she may, if she has a rough pregnancy, she may choose to take. It's 11 weeks before the birth. She can start the maternity leave. So then she would only have.
I don't. My client doesn't really have a position on this, but I can see the dangers. I mean, Mrs. Justice Slade just mentioned it en passant, and quite a lot of people got very excited about it and say, oh, well, perhaps that's the law, that we can then start challenging maternity leave after 26 weeks. I can't see that could possibly be right, because that's the UK's measure of discretion and how the member state has implemented a health and safety, and although it can't be outside the measure, the margin of appreciation of implementing directives to give a year.
You know, I don't find paragraph 44 totally transparent. I don't think it affects this case.
In both cases here, the claimant is challenging period of weeks 3 to 16.
And yes, so we have Capita is 14 weeks of enhanced maternity pay. So, which is why the answer to the 13.6 point in our case, the EAT said, well, it can't possibly be disproportionate to give exactly what the Pregnant Workers Directive says is the minimum. 14 weeks is the minimum. Capita gives 40 weeks. End of story. And that's why that's the answer to the 13.6 proportionality point. If one is to go down the proportionality route, the best way of putting it is to say, is it not in connection with maternity or childbirth to give 14 weeks? Answer, obviously it is, because that's what the Pregnant Workers Directive requires as minimum. I think really that is all I need to say, except I really ought to just deal with the grounds of appeal that I'm needing to face. Ground one is it health and safety or is it childcare? I've dealt with that. Ground two Is Hoffman history or still good law? I dealt with that. Ground 3 at de Berlin, I've dealt with that. That's ground 3 and ground 4. Ground 5, men and women on shared parental leave receive the same treatment. And it's the comparator point. Section 23, straight comparator. If I may be indulged for 3 minutes or so, there's an area of crossover, or an area of the Hextall alley crossover that I think would be useful for me to comment on very shortly. And just say 2 things. First of all, having heard the argument, I accept that this is probably an equality of terms sphere rather than equal treatment. Because it's about the rate of pay, I accept that strictly Capita should have taken the point that the police took and said, you should, under domestic law, be bringing this exclusively as a equality of terms case because you're asking for the same rate of pay as another person, and the rate of pay is an equality of terms case. So I accept that. Second point, we've been back and looked at the Equality Act and section 70. It's not a Westlaw or a Butterworth's typo. It is it's a draftsman error, and therefore, if it becomes
Why do you say that?
because it's in the actual act, the
You
authorised.
say, like I said, there are 2 points. This was in the Queen's printed copy.
Absolutely. And therefore, where it says Schedule 7, Part 2, that must be a draftsman error because Schedule 7, Part 2 has nothing to do with this. But the test then is that you must be abundantly sure about the intended purpose of the statute or provision in question. You must be abundantly sure that by inadvertence the draftsman and Parliament failed to give effect to that purpose. And you must be abundantly sure, because it's of critical importance, of what Parliament meant to say. That's the test. It's a high threshold, and it's INCO Europe and first choice distribution. So if you needed to...
Have you got the citation?
Yes, it's 2000, 1 Weeklies 586 at pages...
1 weekly law report.
1 Weekly Law Reports, 2000, 1 Weekly Law Reports 586 at pages 592 to 3. I think it's Lord Nichols.
I think we established that we didn't really need to get into it.
I suspect you won't need to do that. You certainly don't need to do it in the alley case because mine's not an equal pay case, although I accept that in substance perhaps it is, but it's not been brought that way, and that's not on the notice of appeal against me.
This came up slightly later, case in the House of Lords in which I appeared as counsel, PNASUWT. There was a clear error in the Trade Union and Labour Relations Consolidation Act 1992. The only question is what it was. And I remember that Lord Bingham said that was Parliament's finest hour, was it? It was clear that there was an error. I can't remember what was said about INCO Europe.
Well, it's most recently...
Europe crops up all the time in tax cases because there are always lots of glitches in tax legislation. So
It's most recently come up in this court in Rostock and Gethsemane in relation to the Equality Act, where there was a drafting error. But and INCO was the principle that was used to remedy the drafting error. Third point on this, it's in our supplementary skeleton, the reference to Advocate General Ledger in Northwest Board and McKenna. I won't take you to it, I'll just flag it up. It's paragraph 37, but we quoted it entirely. It's behind tab 11 in the authorities bundle, where the Advocate General says there cannot be a different outcome to the assessment of discriminatory nature of those provisions, depending on whether it falls to be examined in light of equal treatment or equal pay. So it's the point I made in the introduction, is what Advocate General neatly summarises it, and in the Abdullahi case, the full court says that the principle of equal pay, like the principle of non-discrimination, of which it's a particular expression, and it makes absolute sense. It's all part of one thing. Finally, on PCP, I put this forward, hopefully that it will help assist the analysis. And it's very short. Is this a case in which men and women are paid statutory parental leave pay if they pass an assessment? Shared parental leave pay if they pass an assessment. That's the ESOP case. Ethnic minorities found it harder to pass the assessment than others. Is this a case in which men and women are paid shared parental leave pay if, depending on their length of service? The Naeem case about Muslim chaplains, Christian chaplains. Is this a case in which men and women are paid shared parental leave pay if they are full-time, or if they are 5'4", or if they do shift work? All those are cases in which the PCP has an inherent disadvantage to one category of person to another. And no matter how I've looked at it, I haven't been able to create a PCP which has any inherent disadvantage in relation to shared parental leave pay. The shared parental leave PCP affects everybody the same. It's only if you go outside of shared parental leave and look at somebody in different circumstances, in different material circumstances, who's on maternity leave, that you have any upset at all. Mr. Hextall is only upset because he sees somebody who's in a different circumstance who's being paid more. And that's why I say that indirect discrimination comes down to the same answer as everything else, the Section 23 point. And that, I'm trying...
want to prevent any claim of discrimination, indirect discrimination.
Those are my submissions.
Thank you very much indeed. You've been so succinct there. Now, is this right? We're now back to you. Is that right, Mr. Fazil?
Well, I'm in the
Last
court's
word.
hands.
Sorry?
I'm in the court's hands. I'm prepared to go now and take about 5 or 6 minutes to quickly reply. Or if my learned friend wishes to reply instead first, I'm happy to wait for that.
Right. Now, right, we'll hear Mr. Leach first. If you want to, is that right? You have a right to reply. No. Sorry, no. It's Miss Mambara. That's right. Sorry, I'm so sorry.
Thank you.
Yes, you're quite right.
Just very briefly, if I may, I'm not going to take too much time on this. There are just 1 or 2 points that I think I ought to reply. I'm sure, my Lord, my Lady, you have it, but my submission in relation to Hoffman is not that it should be consigned to the history books, but that it should be approached with considerable caution in the light of policy and legislative developments at EU at level and domestically. As far as the submissions that were made about the substance of Mr. Ali's case, it's perhaps right that I say at this point that Mr. Ali was seeking to take his leave, as you perhaps discerned from the papers, because there was a health and safety requirement that his wife return to work as opposed to refrain from it. And that was why this whole process began. She was advised to take leave in order to protect her health and her well-being. Sorry, to return to work to protect her health and well-being. And as a result of that, they decided that Mr. Ali should seek leave to care for his child.
Yes.
So it's difficult in terms of where to start. The assumptions that are made in Hoffman that have been made during the course of submissions about what benefits women and what benefits men cannot simply be uncritically accepted. One has to reflect on the stated intentions of substantive equality as between men and women in the workplace, and achieving a breaking down of gender stereotypical roles. But lest I, the only other matter was in relation to the Working Families submission, which related to 26 weeks and where that came from. I can, insofar as it assists, they were relying on World Health Organization research, which indicated that by 26 weeks, I think it was something like 90% of women had ceased to breastfeed. And so that was a point at which they considered it appropriate to advance the detachment from the biological features of childbirth and breastfeeding and pregnancy. But I'm not sure that's a principled basis for making any assessment of when detachment occurs. But I don't wish to trespass on your time any further, so those are the submissions I have in
Very
reply.
grateful to you. Thank you very much. Yes.
Lord Murray, starting with the equal pay, equal terms point, the equal terms provisions will apply even if the claimant disavows all reliance on the term which a comparable female officer has that he does not have, if that's the source of the disparity that really gives rise to the concern he has, or the shortfall that he complains of.
Right,
So it's a matter of legal status.
Right. So you mean if he actually has the term,
If he hasn't got the term,
he hasn't got the term. So if he has, right, if he hasn't got
so
the
if he's missing the term,
yes.
it's not open to him to say, well, I've got a different term that's the same as women's terms, and therefore I'm going to rely on that, and say that gives rise to indirect discrimination. If, in reality, he is saying, I don't have at least part of the maternity pay rights of a female police officer. And that is essentially what he is saying in my submission. So it's a matter of legal status. It is a question of reality of what is the source of the disparity. And the source of the disparity is Regulation 29 and Annex L. It is a terms case. Even if the claimant or the respondent in this disavows all reliance on the maternity leave and pay clause of his
Trying to understand
terms.
the solution. Are you saying that we have to look at the reality, and the reality is that Mr. Hextall is saying, I haven't got, but I want part of the term that the women have. Is that what you're saying?
That's right, because when he
Yeah, that's fine. I just want to understand.
when he claims his loss, if he wins, he'll say, well, the female officer received full pay during this time, and I would have received full pay had I been in that situation. So that's the way he will run his claim for compensation if he's allowed to run it as an indirect discrimination claim for mistreatment. In reality, he's wanting part of the benefit of the Regulation 29 Annex L term.
Regulation 29.
Yes, and Annex L term, which is the maternity pay and leave provision.
Yes.
So it's a question of legal status. One can't simply frame the claim differently and say, well, look, I'm just looking at my shared parental leave rights. They're the same as a female officer's parental leave rights.
That's a curious expression, legal status. Is that some term of art? I mean, I understand you to speak. I'm sorry. That's like speaking simple English. I mean, what I understand you to say is that you have to look at the substance of what he has got or hasn't got, and what he wants. Is that what you mean?
When I say legal status, I say that one has to look at the reality of what he's
The reality, I understand.
concerned about, what his claim really boils down to. And it's not about whether he claims it or not, because what he's sought to do is to claim something different. He is disguising his claim. I'm not suggesting he's misleading anybody, he's disguising his claim as an indirect discrimination
What
claim.
is the proper characterisation of his claim?
That's a better way of putting it.
All right. Yes.
And then moving to indirect discrimination via this point, it's a point raised, I think, twice by my Lord Justice Bean about pay being included within the PCP. So my learned friend was asked for examples of cases in which the PCP itself incorporated a term or a provision in relation to the rate of pay. And yesterday he went straight to Steinecker, tab 7, and that's a case, he said, related to pay as part of the provision for general practice applied to the employee in question. Wrong. If we can go to Steinecker very briefly, tab 7, paragraph 26. We see immediately there.
What tab, sorry? What tab?
Sorry, that's tab 7, and it's paragraph 26 of the judgment. The PCP in that case is the requirement to work full-time for 3 of the 5 years preceding the advantage she sought to take. So it's not a PCP which incorporates a rate of pay, because that is what causes PC Hextall the problem that I'll come on to. Let me move from that question to the question of the pool, because it's connected, the pool selected by the Employment Tribunal, insofar as it's possible to discern the pool they did select. Well, let me try and explain why it's hard to see a process of logic that's set out in the tribunal judgment, because it's rather too simple. It's simple because of the point made in ESOP. If I can start, that's tab 30. It's paragraph 40 of the judgment given by Baroness Hale on behalf of the court, with which the other members of the court agreed. Paragraph 40, about 4 or 5 lines down, or 3 or 4 lines down, Lord Justice Sedley said that a pool chosen to be that which suitably tests the particular discrimination complained of, and then the material words, in relation to the indirect discrimination claim in Allenby, he observed that identifying the pool was not a matter of discretion or of fact-finding, but of logic. And then if we move down then to paragraph 41, the last 4 lines of paragraph 41, just above 42, against the letter H, there is no warrant for including only some of the persons affected by the PCP for comparison purposes. In general, therefore, identifying the PCP will also identify the pool for comparison. And we say that's what happened here, that my learned friend selected the pool, it included a rate of pay, and that's why one sees the very simple, short analysis in the tribunal judgment talking about men and women being paid X, and that X being set the same for each of them, taking shared parental leave. So there's no need to see a process of logic gone through, because in this case the pool identified itself from the PCP, because the PCP included the rate of pay, hence paragraph 63 of the Employment Tribunal's judgment. And it's rather like the example of the Secretary of State and Rutherford, as I sought to explain yesterday.
in this case, the pool identifies itself from the PCP, which included pay. Sorry, what was it? So what is the consequence of that?
Well, the consequence of incorporating the rate of pay, which is really the complaint, into the pool,
Yes.
is that into the PCP, is that the pool will itself be defined by that, and therefore you're going to result in the answer you see at paragraph 63 of the Employment Tribunal's
Right,
judgment.
so what you're saying is that because the PCP includes the rate of pay, everyone in the pool has to be getting that rate of pay, and it's only people who are taking shared paternity leave and
Parental
not
leave,
people who are taking shared parental leave, and not people who are taking maternity leave who suffer that particular disadvantage.
Yes. That's a short answer to the claim which the Employment Tribunal gave, because of the way that the PCP was framed. And that's why one doesn't see PCPs framed in that way. One sees a requirement like the height requirement or part-time working, that sort of
But
thing.
the point, the point here is it's not people who are at any one moment taking it. It's people who are or who may want to take it in the future. That does include people who currently may be on maternity leave, but in due course may want to have shared parental leave.
Yes, and if they do, they get paid X. They get paid the statutory
Yes,
rate.
but the PCP is defined by all the people who are or may wish to suffer that PCP. When you come to decide whether or not any particular person is disadvantaged, we're not looking at a comparative exercise. Then that's a different issue. You have to find two groups that are in all material respects alike. I don't follow your point at the moment that because at any one moment of time somebody may be in maternity and then in statutory, we exclude all those who are in maternity. I don't understand that. Women who are all women may at some point or other after childbirth want to have shared parental leave. Therefore, they are people who at that point will be subject to the same PCP. Why should they be excluded from the pool?
Because of the way the pool is framed. It's framed by virtue of, it incorporates the rate of pay within.
Yes, well, there are people who in due course may have that. Anyway, look, there we are. It's interesting that both, as I see it, both you and Mr. Leach seem to want to bring this issue, for your own particular forensic reasons, forward to the point of defining the pool. Anyway, there we are.
Well,
And you reach different conclusions on that.
Well, I say the pool has defined itself, because this is an unusual PCP which cannot produce a disparity because of the way it's framed.
Yeah.
Because it doesn't contain something which is like a height bar, a strength
Yeah,
bar.
but you accepted, we were asked directly whether you accept that the PCP was correct, and you said yes, you accept it's correct.
I do accept that it's correct. There are many PCPs applied by employers and quasi-employers up and down the country. I accept it's correct. Why wouldn't I, given that its effects are not indirectly discriminatory?
But you also accept that within the pool you have all employees who are or may in the future satisfy the terms of the PCP.
Well, that's right, and because it includes a term relating to pay, which is unusual, if not unprecedented, it's hard to find an example of a case which contains that. It has defined a pool automatically, if you look at the logic at the end of paragraph 41 of Baroness Hale's judgment, that involves the male group and the female group both being paid the statutory rate. And finally, in effect, what's being complained about, the substance of what's being complained about, is to qualify for enhanced pay when you're taking leave in connection with the care of your child. what's being suggested is that you have to be able to access something like maternity pay. And so at the moment, what's being suggested is that you can only access that enhanced rate if you have given birth. And that was rather like my Lord Justice Bean's hypothetical of the individual or the competitors for a promotion who are only eligible for it, for the better rate of pay and the free housing or whatever, if they have given birth. And my note suggests that when my own friend Mr. Leach was asked whether he thought that was indirect sex discrimination or direct sex discrimination, he correctly said direct sex discrimination. And there's no real difference between that situation and the substance of PC Hextall's complaint. And if that's right, it's a direct discrimination, but really, because it's to do with terms, it's an equal pay claim, which fails for the reasons I explained yesterday. I hope I've assisted more than I've caused furrowed eyebrows by my reply, but it's probably time to stop unless I've got any, unless I can assist any further.
So it's direct discrimination. You say it's direct discrimination because it's framed.
Well, because the substance is like the eligibility criterion for the better job with the free house, where you need to have given birth to be qualified for it. That's direct sex discrimination, that condition.
Brilliant. I think what you said was it's direct discrimination because it's been framed as an equal pay.
No. I may have been unclear, but what I'm saying is that is direct discrimination because it is an apparent PCP, like in James and Eastleigh Borough Council, whereby to qualify for the good job with the free house, you've got to have given birth. It's a proxy for sex as a criterion, and so as my learned friend Mr. Leach said, and he's right, that is direct sex discrimination. And direct sex discrimination, when it's relating to terms, as I said at the beginning of my reply, is an equal terms claim. It doesn't really matter because if it's direct discrimination in treatment, it fails for the reasons my learned friend Mr. Burns explained.
Any questions? Yeah, well, thank you very much indeed. I'm extremely grateful to all council for their detailed submissions on this matter. Obviously, it raises important issues. We will consider our judgments. When you do receive the judgments in draft, please do agree a full folder. Any further submissions to be in writing. Thank you all very much.
Right.